years in Hungary, we had a situation where thousands of asylum seekers were arbitrarily detained in the transit zone at the border, including families with children, unaccompanied minors, vulnerable asylum seekers. We had tried several tactics. Of course, advocacy, there was also support from international bodies, UN, Council of Europe, writing reports on how transit zone does constitute detention. We tried individual case litigation, in most of the cases with no success. It is only with strategic litigation that we actually achieved that a preliminary reference was referred to the European Court of Justice, and finally there was a judgment confirming what we always believed, that transit zones are detention and that people kept there were arbitrarily detained. Following the judgment, the Hungarian authorities finally closed the controversial transit zones, and at that moment more than 300 asylum seekers were finally free. This is the result of strategic litigation, and we believe it really shows how important it is and how sometimes this is the only way to actually make a change.
The Hungarian Helsinki Committee in recent years has become one of the leading players in the field of strategic litigation for international protection-related matters in Europe. We have taken more than 100 cases to the European Court of Human Rights. We obtained 44 interim measures from the same court in recent years. Through these interim measures, we could prevent imminent returns to very dangerous places which would have caused serious human rights violations, probably even the death of our clients. We could address the systematic, deliberate starvation of asylum seekers held in Hungarian transit zones. And we could also address inhuman detention conditions. We have also taken several cases successfully to the Court of Justice of the European Union. We already count 9 victories before this court, probably more than any other organization in Europe. But what is strategic litigation? Litigation basically means that you take cases to court. Strategic litigation means that you do this strategically. You do this with a special objective that goes beyond the mere conditions, the mere circumstances of the case. By taking cases to court in a strategic manner, you would like to reach a larger social or legal change. Therefore, strategic litigation is different from legal aid or general legal assistance. Most lawyers, when they provide assistance to their clients, they aim at that case. Their main focus is on that case. What they want is to resolve the situation of their client. When you do strategic litigation, of course, you want to resolve the situation of your client. You want to prevent human rights violations of that particular person's case. You would like to reach refugee status or other protection status for that person. But you also would like to reach a decision which will have an impact on the life of other hundreds, thousands, tens of thousands, or even millions of people. The problems we need to tackle through strategic litigation may emanate from the law. So the text of the law is wrong. It's something which is against international obligations, against humanity, against international law. But it can also emanate from policy. We see around the world cases where the law is fine, but there are some instructions, public or non-public instructions by administrative organs, by ministers, by state secretaries, or just general directors of immigration services, which violate human rights obligations. And after all, sometimes problems that we would like to tackle through strategic litigation simply emanate from practice, from the practice of those who take decisions day by day, who review detention cases, who decide on refugee status, stateless status, who are there to protect the rights of unaccompanied minors, for example, but who don't do that in practice. What is common for all the problems we would like to tackle through strategic litigation is the systemic and systematic character of these problems. It's systematic because it happens often. It's not just a one-off. It's not just a single mistake that an authority or a judge commits. It's something that is there for a longer period of time that concerns various people in need. But it's also systemic, which means that it is deeply rooted in the system. It's deeply rooted in the political will, in the social attitude, or in other circumstances of the country. This is why this systematic and systemic character, which makes strategic litigation is so important because these problems are often impossible to tackle in any other way. Just by mere training, for example, or writing a few articles or doing advocacy or policy work, these problems, which are deeply rooted, will not disappear. We need more than that. We need the power of the judiciary to put an end to these issues. Strategic litigation can be useful in various areas related to international protection. First of all, we resort to strategic litigation when it comes to the application of classic refugee law. So, for example, when deciding whether a person is in need of refugee status under the Geneva Convention or any other extended concept of protection. For example, subsidiary or complementary protection, extended refugee definitions as they exist in Africa or Latin America, or any other humanitarian status that is close to what we recognize as refugees under international law. It's also useful in other related areas of international protection which do not fall under the scope of classic refugee law. For example, in countries which foresee a specific status for stateless persons, strategic litigation can be very important in these procedures. Or any other protection measures that are aimed at victims of trafficking, of unaccompanied minor migrants, torture victims, or any other migrant who may be in a particularly vulnerable situation and need international protection. Strategic litigation in the field of international protection may often have to tackle areas like immigration detention or the specific detention of asylum seekers or any kind of de facto arbitrary detention or confinement. Sometimes protection needs arise in the larger context of immigration or aliens law, for example, expulsion procedures, extradition procedures, or, for example, family reunification procedures. These are also areas which may be intimately related to international protection. Sometimes there are risks of grave human rights violations, and our strategic litigation efforts often have to operate in these procedural frameworks and not necessarily just the framework of determining about protection needs in an asylum or any other procedure. And finally, strategic litigation may also be needed in contexts related to the durable solutions we need for persons in need of international protection. For example, some countries allow for judicial review in naturalization procedures, or it may also be useful when it comes to the prevention of statelessness among refugee children or children of other beneficiaries of international protection.
Regarding the question which court to turn to, in domestic litigation, of course, it depends on the legal regime. So usually certain decisions can only be challenged at the prescribed court which has jurisdiction. But sometimes you might have a choice there as well. For example, when you have to decide whether you will tackle the issue through the compensation claims, so you would turn to the civil courts, or you would tackle it through the either criminal or administrative courts. Of course, important is that you try to exhaust all existing domestic remedies, especially if later on you would want to turn to international court, which usually has this requirement that you first need to exhaust all possible domestic remedies and only later you can turn to the international courts. But sometimes when the remedy is not really the required one in order to fulfill this criteria that you exhausted all domestic remedies, then it's where the strategic thinking actually plays a role, because sometimes you might not want to turn to the Supreme Court or to any other type of courts because you would consider that this might not be beneficial for your case. Then certain countries also have constitutional courts. Of course, to challenge the issue at the constitutional court, you would need to show that the constitution, that constitutional rights, fundamental rights have been violated, which sometimes it's not the case, and therefore you would not want to turn to this court. It is also important to show that if the court, the constitutional court actually has the capacity to judge whether certain decision or law is in harmony with the international law, then this could be a good venue to use to get the right decision. And as I already mentioned, sometimes you will have to turn to the international courts because domestic remedies were just not efficient. We have, for example, in Europe, the European Court on Human Rights. We also have the Court of Justice of the European Union, for which, of course, it is not only up to the lawyer and up to the applicant whether you want to turn there or not. It's the judge who actually decides. In the Americas, you have Inter-American Court on Human Rights. In Africa, you have African Court on Human and People's Rights. It is also important not to forget about the UN complaint mechanisms, such as, for example, Convention Against Torture that has its own committee, or Committee on the Rights of Children, or United Nations Group on Arbitrary Detention. Sometimes these venues could be very useful because their understanding of particular convention treaty is sometimes more favorable than, for example, the understanding of the European Court of Human Rights. There are different types of strategic litigation. For example, mass strategic litigation is also one of them, which means bringing to the court as many cases as possible to achieve the jurisprudence overload, which might then force the lawmakers or the state authorities to actually change the problematic practice. This might also be useful when you know that not all the judges would be open for the problems that you are addressing, and you would need to have the right judge who would actually understand the matter and be willing to address the problematic issues. And to get to the right judge, you need to have a lot of cases. Of course, this is very resource intensive and it's therefore not always possible. Another type is a selective litigation strategy, where you, based on clear criteria, choose the right case, you bring it to the right forum, as we discussed previously, and then you actually get the right decision that would then influence the similar cases. It is very important to note that strategic litigation can as well coexist with the regular legal aid provisions. For example, in Hungarian Helsinki Committee, we are at the same time doing strategic litigation as well as general legal aid assistance. And this enables us to actually have access to different cases, to different clients, and to be able to choose which case would be the strategic one that we would then bring further to the strategic litigation avenues. At the Hungarian Helsinki Committee, we believe that it's also very important to connect with other countries that face similar legal issues and to coordinate our efforts in strategic litigation, to share the legal briefs, the arguments, have discussions, try to help each other with strategic litigation efforts, because if one country manages to get a change regarding the interpretation of certain law, then this might be beneficial for other countries as well. Therefore, this transnational cooperation is very important.
Usually the first immediate impact of strategic litigation is that the jurisprudence changes. So for example, when there is diverging jurisprudence on a certain issue in a country, different regional courts decides differently, then you may take a case to the Supreme Court or to the Constitutional Court, which will tell the national judges which interpretation is the correct one. In many other cases, what we aim for is to change the practices of the state, so the administrative authorities. For example, in 2019, a Mexican court intervened in order to put an end to the immigration detention of children. Another type of impact that strategic litigation may have is to change the law itself, so the problematic legal provisions, to amend the text directly, or to force the parliament or the government to amend the text, or just simply suspend the application of problematic provision. This happened, for example, in South Africa in 2020, where a South African court suspended some provisions of the South African Refugee Act, which said that asylum seekers, for merely not prolonging their visa for a month, can be automatically sent back to their country of origin. Or another example, which was of historic importance in the defense of stateless persons, when the Hungarian Constitutional Court in 2015 ruled that the Hungarian provision, which obliged applicants for stateless status to have already a legal residence in Hungary in order to be able to apply for their status, the Hungarian Constitutional Court ruled that this provision was against Hungary's international obligations and simply quashed that part of the law. And after all, strategic litigation also aims at changing society. For example, when a big decision is passed by a constitutional court, by an international court, that often has an impact of how we see things, how we look at certain populations, certain people in need, how we look at protection needs. For instance, when in 2008 the High Court of Bangladesh granted Bangladeshi nationality to the children of a stateless generation born in Bangladesh already, the Bihari population, that told a lot to the people of Bangladesh about how the state or the judicial power started looking at these populations as part of society, as part of the nation. Or when a couple of years ago, the French Constitutional Court decided that helping an asylum seeker to have access to territory can never be a criminal act if it is practiced with a humanitarian purpose. It also told a lot to French society or to European society, saying that these things are morally right and these should never be criminalized. I think these are probably the most beautiful impacts of strategic litigation, where it's not that you change practices, jurisprudence, change how certain state decision makers operate in their daily practice, but you actually change social attitudes in the long run. And that's usually a historical achievement.
Strategic litigation can be made by individual lawyers, law firms, NGOs, legal clinics, or in combination of these. You need at least two actors, an actual lawyer who will litigate the case, as well as an expert who would coordinate the strategic litigation. Coordination is equally important to actual litigation, because without the coordination, it would just be an individual case litigation and it wouldn't have this strategic aspect. NGOs, legal clinics, specialized law firms or international organizations can do a lot to help to address the coordination aspect. Tasks related to legal representation are the following. You need to obtain a power of attorney. You have to do legal counseling with the client. You write different legal submissions to different courts. You do court pleadings, if necessary. As well, it is important to be available after the judgment is delivered, because it's not only to achieve a good judgment, the implementation of the judgment is also a very important aspect in strategic litigation. Tasks related to coordination are the following: identification of problems, issues, finding out which is the good case, which is the strategic case that should be litigated, liaising with different lawyers and other actors around, providing background research, actually helping with the submissions, trying to get assistance from external actors, for example, for amicus curiae or for any other support from, for example, from UNHCR or academics or any other relevant actors in the field. What you would need is, first of all, access to people in need. Sometimes when direct access is not possible, indirect access through, for example, social workers or other people that have access is equally important. You would need lawyers, knowledgeable lawyers, that are ready to embark on sometimes a very lengthy journey that does not always bring results. What is very important is to keep contact with the client through all the strategic litigation process, which can be very lengthy. And sometimes this can be difficult, especially in the field of migration, where people can be on the move. And finally, funding is very important, from state legal aid or NGOs or international organizations. Professional strategic litigation cannot function without a proper funding. It is not sustainable to conduct a professional strategic litigation on a pro bono basis.
While strategic litigation is primarily a legal process, there are also several non-legal tasks that are attached to it which are equally important. And these tasks are those which make strategic litigation truly strategic. One of these tasks is advocacy. When you have a pending court procedure of strategic litigation, it can be extremely useful if at the same time there is a parliamentary committee or the ombudsperson or a UN committee or special rapporteur issues a special report on the same situation, a critical report, remarks it, even if it's not an official intervention in the case itself, it's not an amicus curiae, it's not an official third-party intervention, but it's something which concerns the problem in focus. Besides advocacy, media coverage can be very useful, but also sometimes very harmful. So when you decide on mediatizing your strategic litigation case, it is very recommendable to conduct a very careful risk and benefit analysis. In some cases, media coverage can be extremely useful. It can push the court in the right direction. It can create a social support movement even for the case. In other situations, it can be very dangerous. For example, it can seriously harm the victim or the applicant or the client in the strategic litigation case. It may also put undesired pressure on the judicial authorities, which will push them in the wrong direction. So media coverage can be as good as bad it can be in some other cases. But especially in mediatized cases, what you will also need to work on is what we would call victim care or client care. Strategic litigation may be an extremely long process. Sometimes it takes years or even a decade to get to a final decision. The client, the victim, the asylum seeker who is in the center of this procedure may need not only legal assistance during this time, but also, for example, psychological support or communication support. If he or she agrees to be seen by the media, to probably push his or her own case through media representations, it would be very useful if that person has access to a professional helper in that sense, who can train him or her on how to talk to the media, how to talk publicly, and so on. Psychological and psychosocial support can be equally crucial, as these procedures are quite burdensome for any individual, and especially for those vulnerable individuals who are forced to flee their homes and seek protection elsewhere. Professional support can really make this whole experience less difficult for them. The cooperation between legal entities on one hand, NGOs, lawyers, and psychosocial entities, medical, psychologically focused NGOs or service providers on the other hand, is considered a good practice and can really make your client's life easier in these difficult situations.
UNHCR can do a lot to support strategic litigation. For example, they can directly intervene by submitting amicus curiae, which is a direct intervention in the actual case. They can also write their expert opinions or statements concerning certain legal issue. UNHCR can also provide training for lawyers, which is very much needed. UNHCR can also promote this strategic litigation model that we've just described and provide funding for tasks that are often not funded by anyone, such as, for example, the coordination of the strategic litigation. Academics can also play a very important role in strategic litigation. Them as well can directly intervene by submitting a third-party intervention in a concrete case. Academics can do legal analysis, for example, a comparative law analysis. Jurisprudence of international courts shows that such a comparative analysis is often of a big added value in the actual case. Academics can also scrutinize the bad judgments and apply the existing legal theory in order to point to where the judgment went wrong.
So if after watching this short video you have become very interested in doing strategic litigation, you may ask yourself what are the next steps in a context where probably not all this infrastructure exists yet. I would advise you to follow 4 steps in order to build strategic litigation capacities. So in a domestic context where no structures exist yet for strategic litigation in the field of international protection, what you first need is mapping. First of all, we have to find out which courts are competent, where to turn to, where to start the cases, where to find the clients, where are the other actors who can positively intervene in your cases. It may be surprising, but in many national contexts, we still miss this information. Without this information, it is not possible to do anything else. The usual second step is awareness raising. We have to make sure that all the litigators, all the lawyers, the NGOs, all the other actors in the field are aware of the importance of strategic litigation. They understand that this can actually bring legal and social change. This is the reason for which we have also prepared this short video. And it can be very useful to show examples from other countries, probably in the same region, where this has already brought spectacular results. Once the proper awareness and motivation is reached, it's very important to train the different stakeholders in the process as the third step. This means the training of lawyers who will act as strategic litigators, to train NGOs, legal clinics, and other actors who will participate in this, who will coordinate this process. It is also very important to train judges. This may be more tricky because judges often do not or cannot accept training by any actor. They usually accept training by their own judicial institutions or by other judges. But also in this context, the help of UNHCR can be crucial, as well as the cooperation of judicial associations or training fora, like the International Association of Refugee and Migration Law Judges, or entities like the European Judicial Training Network in Europe, or the national judicial academies or training institutions. And after all, what we need to reach is a sustainable scheme for strategic litigation. Besides the awareness, besides the knowledge, besides the access to clients, it also requires some sort of stable funding, some sort of stable institutional framework in which this can exist over several years. In a world where migrants, refugees, and people who are different, who come from elsewhere, are often used by politicians for scapegoating, for creating hatred, very often your only ally to keep up with international human rights standards will be the judiciary. This is why strategic litigation is today a crucial means for protecting the space that we have achieved, the space we have managed to build for refugees in this world.
Strategic litigation can be a lengthy and difficult process with a lot of obstacles to overcome. But at the same time, for a lawyer, it can be very exciting and interesting. And the final positive result is one of the most rewarding things that a human rights lawyer can actually achieve.